And welcome to Law&Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. We're doing something a little bit different today. We are live in a major hearing in the Lori Vallow Daybell and Chad Daybell case. This, of course, is that Idaho couple who have been criminally charged in connection with the grisly discovery of Lori's children, JJ and Tylee. This hearing is to determine if the lead prosecutor in this case, Rob Wood, should be kicked off, be disqualified for having what the defense is saying are inappropriate conversations with two key witnesses in this case. Lori Vallow's sister, Summer Shiflett, and her former sister-in-law, Zulema Pastanis. We just heard a secret recording of Rob Wood and Summer where he said that they intended to file conspiracy to commit murder charges against this couple, and he hopes that she'll testify and provide some context. The question is, did he say anything wrong, unethical, that should get him kicked off? Let's go live to this hearing right now.
Way into this, Mr. Wood, on the supposed idea that he was going to do a meet and greet, proceeds to engage in Miss Shiflett, and by my recollection, he only asked a couple of questions, but there was a lot of discussion. And in that discussion, he invoked his religious views. So in other words, he's telling a witness who is going to be testifying in the trial, by the way, I'm LDS. By the way, I'm Mormon. Show me some favor. And that way, when you get in front of the jury and you offer that testimony, the intimidation and the influence has already occurred before you get in front of the jury. So in many ways, isn't that worse?
Your Honor, I'm going to object. Mr. Pryor's testifying. It's not a question. He's leading the witness to an answer.
I'll sustain the objection.
What's worse, doing this in front of a jury or coercing and intimidating a witness prior to the time they go in front of a jury?
Your Honor, I'm going to also object to the question. This doesn't have anything to do with the jury. It's just a witness in a case. So it's not relevant.
I'll sustain that objection based on relevance, and I think it did misstate the statements contained in the recording, which we just listened to, so that objection's also sustained.
All right, I'll move on, Judge. Thank you. What about calling a defendant in a case a wimpy person, Mr. Smith? Is that problematic?
You know, I know there's a lot of bluster that goes on in prosecuting people that do violent things. You know, I never prosecuted murder cases. I was involved with prosecuting child molesters. And there's a fair amount of banter that goes on amongst the professionals in there about these kinds of people. And so I've been to lunches where they referred to child molesters by lots of names that were demeaning and not nice and unprofessional. But it's in a professional setting. You know, I'm at lunch with other prosecutors or cops, and we're talking about, what we think about child molesters. But in the context of talking to, the sister-in-law of the individual that you're talking about, I didn't see a purpose for that. Other than to, kind of seed the ground for her testimony to be of a similar vein. And, this is what we're looking for, kind of thing. And that was concerning to me.
And the concern is that Summer Shiflett is a witness potentially in this case, right?
Right. I mean, and I haven't been a prosecutor in a long time, but to talk to someone prior to them giving 6 hours of testimony and interview time on the facts of a case in this manner, I found it to be improper. I don't know what purpose it served, other than to kind of muddy the water and make himself a witness.
Well, and make himself a witness because he then went on to discuss the fact that when he was in Hawaii, I don't know why he was in Hawaii other than apparently he was in Hawaii, but then he observes what he says appears that the defendant, Mr. Daybell, appeared that he was about to pee his pants. What's the purpose of saying that to Summer Shiflett?
Your Honor, I'll object. That just calls for speculation.
I agree. It is speculative, but I don't know. That's my whole point. I don't know that. And Mr. Pryor, let me say this too, just in response to that last question.
Mr. Smith.
I'm sorry?
Mr. Smith, please.
Yes.
We're on a Zoom proceeding. We're making a record here. I have a court reporter.
Okay.
Wait until the questions are finished, and when there's an objection, please wait for the ruling on the objection before you continue with your response, please. Thank you.
Sorry, Judge, I'm not good at being in this seat. I apologize.
Understood.
Where are we at?
I heard an objection from somebody. I'm not sure who objected, but
Mr.
I'm waiting for the court's determination.
I sustain an objection by Mr.
Okay. All right, I'll continue on. Mr. Smith, you had some discussion about a prior question and that you had a comment, and if you want to relay that comment, by all means.
This conversation that I had with my client and Mr. Wood, again, and just earlier I had testified that I didn't remember when I started the recording. From listening to the recording, I clearly started it after I got into the room. And to be completely candid with this court, my intent was to record the conversations of the interview. When I walked into the room with Mr. Wood, it had a less of an introductory feeling to it because he brought his deputy in with him. And again, part of the training that I received as a prosecutor and that I still employ as a defense attorney is that there needs to be somebody else in the conversation that can be a witness in case there's a dispute to that conversation. So if I'm interviewing a witness and I ask that witness about X, Y, and Z, and then they come into court and testify A, B, and C, I have to have some method of impeaching them, either through another witness or recording of the call or something like that. So a flag went off in my mind when he brought his deputy in to meet my client and myself, and to kind of do this introduction stuff. And that's when I got my recorder out and turned it on. That put a flag off in my mind that this wasn't going to be, hey, I'm John, or I'm Rob. This is my deputy. Good luck today. Thanks for doing this, and we'll talk to you when it's all done. It was more than that, and that's when I turned it on. And I wanted to supplement my previous testimony. Like I said, I hadn't heard the tape recording in a while, and I didn't remember when I'd turned it on.
And when you make mention of the fact that a flag went off, you're referring to the fact that you felt that there may be some inappropriate discussion going to take place. Is that fair?
No, I didn't think it was going to be inappropriate. I thought it was going to be adversarial.
Okay.
And the fact that he was backing himself up with a witness told me, at least it made my, the flag, the spider senses, whatever you want to call it, the defense instinct, that I needed to be recording this conversation because he's got a witness in here. I need to have my recorder running. I had no idea that the conversation was going to go the direction that it went.
And having participated in the conversation, the 18-minute discussion, because this wasn't Mr. Wood questioning Summer Shiflett, was it?
No.
This discussion was Mr. Wood presenting his case to a witness. Would you agree with that?
Yes.
And Mr. Wood attempting to influence Summer Shiflett to testify a certain way. Would you agree with that?
Again, I don't know what his intents were, but I can't see any other reason to tell her the things that he did other than to steer her in that direction.
And when you say steer, you mean influence, do you not?
Correct. It's another word for that. Yes.
Okay. Judge, I think at this time, I'm done questioning with Mr. Smith. Thank you, Mr. Smith, and I'll defer to the court at this time.
All right, thank you. I'll allow cross-examination at this time. Mr. Evans.
Your Honor, thank you. Mr. Smith, thank you for being here today. Just a few questions. Where was the recorder at when this was being recorded?
It was my phone. It was this phone. And it was either in my hand or it was sitting on the table. I don't remember. I think we were standing for this conversation. I think we never sat down. We were standing in a small ante room off of the entry lobby of the Chandler Police Department. I think I'd set my stuff down on a table and my phone was on top of that.
And just so I understand this, Mr. Wood or the law enforcement, they contacted you and you contacted your client and you agreed to this conversation taking place, this meeting taking place?
Yes.
Mr. Smith, I mean, we're all lawyers. If something gets out of hand, and I know you've done this and we've all done this, but if I'm getting on your client's case, you can say, Evans, time out. Or I'm going to direct my client not to answer that question, or this interview is over, right?
Sure.
At no time during this meeting did you ever object to any question. Is that correct?
Yeah, I was doing what my client wanted to do, which was to participate in this interview. And you got to understand, I wasn't running it. She was running it. I was there as legal counsel, and she wanted to do this interview. She wanted to give testimony. She'd been asked to give testimony. in that sense. And so she was going to do that. I didn't want to shut this down, but that doesn't take away the concerns that I had at the time. There also wasn't a forum to go to. You know, if I've got a problem with the question you're asking, I could object to it in a setting, not in this setting. It's not my position here, but there's a judge to go to, or you know, hey, let's table this right now and straighten this out in a deposition or something like that. But it wasn't that type of setting. This was unique. Like I said, I've done this type of setting many times, but to have this kind of conversation was a little bit, oh, we're doing this. Okay. And I didn't know where it was going to go. I knew I was recording it and I could deal with it later.
But you could have objected or told your client not to answer or ended the conversation, right?
Well, as was said, there wasn't a whole lot of questioning going on. In fact, I don't know there was any questioning other than, you know, a couple of mild questions. It was mostly just conversation from Mr. Wood.
I want to talk about the tone. I mean, you hear you guys are joking a little bit throughout when it was discussed at the very beginning that murder charges might be coming on this. You said good, right? Do you remember that?
I don't remember that, but I don't dispute it.
Is your client a vulnerable adult by chance?
No.
Have any medical issues or anything that makes her incompetent to testify?
Not that I'm aware of.
And then finally, I want to talk about, you made an issue that Mr. Wood started talking about the death penalty or murder charges. I note from the audio, and I don't know, do you have the transcript in front of you, Mr. Smith?
No.
On page 11, starting in paragraph 5, it's pretty clear that your client was the one that initiated that conversation with Mr. Wood of, talk to me about, is death penalty on the table? What's going on?
I'm going to object at this
Yeah,
point.
you're not objectable. Go ahead, John.
Hold on. What's
Go
the,
ahead, I'll defer to Mr. Means, but I object from Mr. Evans questioning in this manner as suggesting that it's obvious that that's Ms. Shiflett that initiated it. I object to the form of the question.
Same, Your Honor.
the objection's overruled. You can continue. Were we referring to the transcript? I know that's been admitted.
I don't have it, but at least I don't think I have it.
Yeah. And let me just, so I actually misspoke. It's page 16, starting paragraph 2 through 9. But your client is the one that's asking Mr. Wood, what's the weight of the terms in jail? Is this a death penalty thing? Do you remember that, Mr. Smith?
I do. Yeah, she definitely initiated that conversation.
Okay.
Mr. Evans, if with the transcript being admitted, if you are going to refer to it, I think, and ask the witness to confirm that, it'd be appropriate if you can publish it based on, I don't know if you have, we should be able to enter it in. And so you can use your share screen to locate that part of it if it's on your computer, and then it comes up on the share screen on the Zoom if you want to do that. And if you're done with the question, that's fine, but for future reference, that's how we need to handle that.
Right. Thank you, Your Honor. And Your Honor, I'm done with that question. Mr. Smith, just a few others. I heard in the interview, Mr. Wood that told you and your client, hey, you don't have to talk to us, but you have agreed to that. Do you agree with that recollection?
Yes.
And it's important. My last question, you said that you didn't believe anything was inappropriate here, but you had a concern that it might turn adversarial. Can you tell us what you meant by being adversarial and not inappropriate?
Yeah, let me be really clear about that. When there was obviously conversation that had transpired prior to the beginning of the recording, we were several minutes into it by the time I turned it on. And the beginning of it did involve Mr. Wood introducing us to him and his deputy and thanking Summer for coming in, kind of like he ended the interview with, or the meeting with. And I went into it, you know, to the day knowing that I was going to record the interview and was prepared to do that. I told my client I was going to do that, you know, those kinds of things. Did not.
So Rob Wood definitely shared a lot with Lori Vallow's sister Summer. The question, of course, is should he be disqualified from the case for what he said? And then we just heard it all on tape. Let's take a break. When we come back, we'll be live in that Zoom hearing, I should say. Be back. All right, we're back live in that hearing in the Daybell case. The question is, should Rob Wood, the lead prosecutor, be kicked off? Now, it should be mentioned that if he's disqualified, he could be subjected to ethics violations, possible liability legally wise. I mean, again, he's been accused of witness intimidation and tampering, and he could be subpoenaed in this case. There's a lot riding on this decision by Judge Boyce. Let's go back live.
Thank you, Your Honor. Mr. Smith, I'll try to avoid repetitive questions here for efficiency of the court. You've listened to this recording. In this recording, Mr. Wood makes reference to speaking to, or sounds like speaking to, multiple people regarding this case. He uses terms of we. He talks specifically about having a conversation with Colby. Are you aware if Mr. Wood has spoken with any other person directly in this case?
I'll tell you what I know, and that's just like I said earlier, that he had told me they were coming down here to interview witnesses. I don't remember that he gave me a list of who he was going to interview, but I mean, I could probably name half the list of the people that he spoke to. He did tell us in his conversations in the interviews, not him, the investigators told us some of the people that they had spoken with. But yeah, I understood he was down here talking to other witnesses about the case, and he may have been down to Arizona one other time. As I indicated earlier, this was, I think, the second setting that they tried to interview my clients in.
Okay. Did you have an opportunity to review a pleading filed in this case entitled "The Affidavit of Rob Wood in Support of Objection to Defendant's Motion to Disqualify Prosecuting Attorney and Motion to Extend Time on Motion to Dismiss"?
I did.
Okay, and this document, Your Honor, is obviously in the file. I'm going to read you paragraph 6 from this affidavit, and I'd like your thoughts on this. It says, the meeting I attended with Mr. Smith, Mrs. Shiflett, and Ms. Pastinas came about as a result of Ms. Pastinas reaching out to my office and law enforcement through her attorney, Mr. Smith. Would you agree with that description?
You know, I don't know if Zulema ever reached out to his office prior to my representation, but I don't believe that I ever reached out on behalf of Zulema to initiate this. My recollection is that they contacted me and said, we'd like to talk to your witnesses or your clients as witnesses.
So would it be your opinion that that is not an accurate statement?
That's my recollection. And again, as I said, I don't know if Ms. Pastinas contacted them prior to my representation, but she never told me about that.
Okay. Well, it says in the paragraph 6, and I'm sorry, the last portion of the sentence, Ms. Pastinas reaching out to my office, in reference to Mr. Wood prosecutor office, and law enforcement through her attorney, Mr. Smith.
Yeah.
So he's specifically stating it was you that reached out to arrange this meeting.
And here's the unique thing in answer to that question, Mr. Means. Here's the unique thing about Ms. Pastinas. Her approach in my representation of her has been to keep her head down and stay out of the limelight and the attention. She's not done any interviews. She's not done any media appearances. She's not agreed to talk to anybody. And the only reason why she agreed to talk to the state is because they wanted to talk to her and they offered her use immunity. And so that's what got us to that point. It was not because she was anxious to talk to anybody, because she was not.
Okay. Okay. I think Mr. Pryor and Mr. Evans covered a lot of the questions I've covered, but I do have just a few more for you. In listening to this recording and the totality of the statement said, you've already testified that it appeared the motive to be influential of the witness. Would you agree it was attempt to coach as well?
The whole conversation, the problem I have with the whole conversation is that, and I'm not saying that Mr. Wood was in there twisting arms or putting hard pressure on them. You know, I've been involved in situations like that where a prosecutor, threatens charges and things like that. That's the real weight of a prosecutor coming to bear on bringing influence on somebody. It wasn't that type of thing. It was the more subtle, I'm a nice guy, and I'm sure he is. You want to help me, help the state, help the case. It wasn't necessary. She was already there willing to participate. She didn't need any inducement or enticing in order to testify. I found it, and that's what my first concern about it was. I was like, why are we doing this? she's already come in, consented to all this. We didn't need to soften the beach with these kinds of comments. And so it clearly was to influence her. It clearly was to have her, kind of seated for this upcoming interview that she was going to have. And just, the next room we were going to go into was going to be this interview. And I saw no purpose for it. And I found it to be unprofessional and concerning.
Would you agree, especially taking in context the conversation regarding death penalty and the relationship in which you testified earlier between Mrs. Shiflett and Lori, that this conversation put Mrs. Shiflett in somewhat of a compromised position as a witness?
Look, as I said earlier, I've been doing this for 27, 28 years. I've been involved with legal practice for 30 years. I have never in my life heard a conversation like the phone call I heard between Lori and Summer. It was gut-wrenching. It is raw. It is horrible to listen to. And this is the emotional state of a witness, my client, who has lost one sister to death, another brother to death, and now another sister to jail and potentially death. And I found the whole conversation unnecessary and concerning. It was almost torturous to even be discussing about, well, we may take another member of your family. And I know Rob's not going to kill her. I mean, it's going to be a death penalty. It's going to be a process, and it's going to be, that whole thing. And but just the purpose of the conversation, I didn't see it. I don't know what it was going to do. And it was concerning to me because I know I've had conversations.
Okay, let's get into this a little bit. Joining me is forensic scientist Jennifer Shen and crime analyst, former SWAT, Lisa Lockwood. I'm happy to have you both here. Lisa, let's just talk about this. There's a separate issue of whether or not Rob Wood is going to be kicked off the case and he's disqualified. But did he reveal way too much information about this case, saying that they intended to file conspiracy to commit murder charges against Lori and Chad? Did he reveal too much in this interview with Summer Shiflett, who he wanted to be a key witness in this case?
Jesse, I think so. This interview is reminiscent of a police interview to warm somebody up in order to give all their cards, to show what they have, to sway them in a particular direction. It was light. It was lighthearted initially. There was some laughter throughout it, but him being able to drop all of these little seeds on the potential of what was going to happen prior to the actual interview that was going to happen after that, I think is very controversial. I don't think there was any reason whatsoever for him to disclose that or to offer opinion about what he thought of Chad Daybell, about him flying to Hawaii and how Chad felt at that moment. I think that part of it was definitely unprofessional.
Jennifer, I'm glad to have you here because another big issue that came up was, again, we're learning more details about this case than we did in the past 6 months. We've always wanted to know, how did Tylee die? And Summer asked Rob Wood, can you give me more information? He says, I really can't. Her body's at the FBI crime lab. There seemed to be a backlog. And due to the decomposed nature of the body, the state that it was in, the destruction of the body, they may never have an answer as to what really happened. What are your thoughts on that?
Well, it's just really so traumatizing for the family. You really want, when something like this happens and there's such a tragedy, you want to have all the answers. You want to know, and you want to know because maybe you'll feel better about how they actually died. When you don't know, then you imagine the worst. So, it's just one of those things. You want to know, but sometimes it's not good to know. Sometimes it's worse to know what actually happened. And just the questions makes it so difficult on the family. There's really no closure when you don't have those answers.
Right. You know what? We are learning more details about this. I want to hit a break. When we come back, we're going to jump live into that Zoom hearing once again. Stay tuned. What an interesting development we have right now in the Daybell case, as it's a big discussion on whether or not the lead prosecutor, Rob Wood, should be disqualified for the conversation that he had with Summer Shiflett, Lori Vallow's sister. Did he pressure her? Did he say these inappropriate things to try to get her on the prosecution side? Is what he did wrong, unethical? Well, we're about to hear a new witness, Dr. James Davidson. Let's go live into this hearing and we'll hear more of what the defense says, their rationale for why this prosecutor should be kicked off the case and become a material witness. Let's go.
Of other psychologists.
Can you give me a little bit of information about your prior experience as an expert testifying in litigation?
I've testified in several states. I'm going to restrict this to criminal matters just for simplicity, but testified in various states on mitigation in Idaho, 1925-22 examinations, 18207 for mental status at time of offense, 18211 for competency, and then general forensic evaluations when there may not be in the criminal code a particular test or structure for a report for an issue. I've done hundreds and hundreds of these in various places, done insanity defenses in states that allow insanity defenses. In Idaho, of course, it's one of 4 that does not, and have done this for probably now 30 years.
Okay. And you mentioned forensic evaluations. Can you elaborate a little bit on what is a forensic evaluation?
Forensic evaluation is the intersection of a legal issue and a field of study, in my case, behavioral health. And so in every state, if we look at criminal issues, a forensic evaluation will deal with a particular issue. So if you have a mental state at time of offense, it is the culpability or the ability of the defendant to rationally be able to understand the consequences of their actions from a mental condition. If somebody has pled guilty to a charge, the court may require or want to have a mitigation report. What's their risk of future violence? What's their mental condition? And that would be used in consideration of sentencing. So a forensic evaluation is going to be an evaluation that will rely upon 5 principal areas. It's going to rely upon interview, testing, observation, record review, and collateral information as a structure, with the nature of the report varying depending on the issue presented to me by the court or by an attorney who's retained my services.
So in other words, asking or an attorney asking you to conduct a forensic evaluation, this is somewhat of a specialized field. Would you agree with me?
It's a highly specialized field, and I would agree with you.
Okay, and in this particular case, this conducting forensic evaluations, have you previously been identified and qualified as an expert witness in offering your testimony and opinion in regards to forensic evaluations?
I have in multiple states.
Okay, and how many times would you believe, you don't have to give me an exact number, have you been qualified as an expert witness to offer an opinion after conducting a forensic evaluation?
I'll tell you that most cases don't require testimony. They are reports used for settlement, or settlement occurs, a plea bargain. But in the last 5 years, looking at, pardon me, civil requirements that I have a 5-year history of testimony, I've testified in over 50 cases.
Okay. So a combination of your educational background and your knowledge in doing this, your skill and experience, you believe that you're qualified to offer an opinion based on what forensic analysis you've been asked to perform. Would that be fair?
Yes.
Okay. Judge, I'm going to move for this witness to be qualified as an expert witness for purposes of offering his opinion in this forensic analysis that he's been asked to perform in this case.
All right, there's a motion. Is there any objection to that, Mr. Evans?
None, Your Honor.
All right, Mr. Davidson will be considered an expert under the rules of evidence and under Idaho Criminal Rule 16 for purposes of this hearing. Based on that, so Mr. Pryor, you can continue with your examination.
Now, Mr. Davidson, I do want to relay that you and I have not spoken about this case prior to this, you being hired. Is that fair?
That's correct.
Mr. Means hired you as an expert to do a forensic analysis in this case. Is that correct?
Yes.
And as part of that forensic analysis, can you relay to the parties in the court what steps you took and what information you had to prepare your report?
Well, the steps that I first took would be to understand what's the nature of the assignment. And in doing an assignment of this nature, I'm always approaching it from a standpoint of I know nothing, I have no prior opinion, and that my task is to provide an unbiased report as if I was appointed by the court directly. So given that, I was informed that the task was to listen and review a recording and a transcript of that recording to determine my impressions based on my experience and training of the nature of that conversation, whether there were any issues or problems, if that conversation was put into context as being a conversation prior to an interview of a witness in a criminal matter. So I listened to the recording. I also went through the transcript and reviewed the transcript. And then based on the training and research that I did concerning interviews in a criminal matter of a witness, formulated my opinions and observations about the appropriateness, the inappropriateness of whatever occurred in that transcript and recording. And out of that generated a report called a Forensic Analysis of Summer Shiflett's Interview by Prosecutor Robert Wood.
Okay. And that report was attached as part of a submission in this particular case. Is that correct? Or if you're not aware of that, that's fine.
I didn't actually submit it. I turned that report into Attorney Means, and I'm sure he submitted it in whatever fashion he did.
Now, I would like to talk about the type of models that are used and how that affects your decision in this particular case. Can you discuss that with me a little bit?
Sure can. Interviewing any witness is an area of great concern because historically, going back decades, interview techniques have been highly prejudicial and biasing and have led to problems such as false testimony. It's led to omission of facts in testimony. And so over the years, internationally, there's been efforts to come up with various models of how to interview a witness to obtain as best as possible untainted, spontaneous information with a really fine grain of detail that would describe what that witness has to offer in testifying about a case. So I have listed in my report, and I'll just run through it very quickly, examples of very prominent models, both in this country and particularly in the United Kingdom and those in its empire. There's the access model, which is an acronym that stands for assess, collect, collate, evaluate, survey, and summarize in interviewing a witness. There is the ABE model, which is in the United Kingdom for interviewing children, achieving best evidence. There's a conversation management model, which is based on the elements of reciprocity, response, and a managed sequence of greeting and orienting the interviewee. There's the peace model, which is used in the United Kingdom and Canada. And the peace model is one that's inquisitorial, but not confrontational or accusatory. And that came about because of issues that they'd had in prior criminal cases of prejudiced and tainted information in high-profile cases. There's the NICHD model. This is a model used particularly when there's allegations of abuse of a child or an adolescent. And it's a model that emphasizes elements that is common to the other models, such as open-ended questions. It emphasizes having a narrative.
Okay, Jennifer, I'm going to give you an opportunity to speak about this witness. But before we do that, Lisa, I want to start with you because we're talking about answers here. The fact that the prosecution was going to file charges, conspiracy to commit murder charges against Lori and Chad, if you believe Rob Wood on that tape, does that signify to you that the real killer, the person who actually killed these children, maybe was Alex Cox? Because why charge them with that if we're trying to create a theory of what ultimately happened with the kids? What does that revelation tell you about what actually happened with these two children.
Jesse, that does make sense. I don't know what information Rob Wood had at that time to think that he could go ahead and bring those charges forward, but giving that information to a family member, I think possibly put her at ease in the sense that they were not Lori, who everybody loved and revered and said what a great mom she was not going to be charged with murder and just the conspiracy part of it. So I don't know what information they had at that point. It's hard to tell because we obviously were not able to go forward with that right now. But if that was an opportunity to put her at ease so that she can feel a little bit better about it, I think that it's possible that it could be construed as coercion.
And now, Jennifer, we're listening about this forensic psychologist. What impact is he going to have on this case? And I can't forget to mention that earlier on, when we were listening to that recording between Rob Wood and Summer, they had a back and forth about, did Lori really know what she was doing? Did she really know what she was doing was wrong or illegal? That brings up questions of course, the insanity defense. And I'm curious, what are we looking out for from this forensic psychologist?
Well, this is sort of interesting to listen to him. He's discussing right now the different ways that you would interview a witness. And what is at play right now is, was there inappropriate behavior between the prosecutor and this potential witness? And, in my experience, having been part of, hundreds of trials, the prosecutors are very, very careful that they do not influence or coerce witnesses because they don't want to have the witness give them information that isn't correct. I mean, at the end of the day, we're trying to find out what the truth is, right? And so you want to have a very honest exchange. So it's very interesting to listen to him. There are many, many models that you can use. And I don't feel like what happened here fits in one of those models particularly.
I'll tell you this much. I don't think Rob Wood ever expected that he would be in front of this judge with his own attorney, Troy Evans, having to defend his actions. And again, he didn't know that he was being recorded. Let's take a break. When we come back, we'll be live in that hearing. Okay, so we're still back live in that hearing, in the Chad Daybell, Lori Vallow Daybell hearing. And this is just an incredible moment that we're having where the lead prosecutor, who we've known so long, Rob Wood, in this case, could be thrown off for what the defense is saying was having inappropriate conversations with two key witnesses in this case. Now, we just are hearing the testimony from Dr. James Davidson, a forensic psychologist, about the impact that these witnesses who are being interviewed by prosecutors, could they be manipulated? Could they feel pressured? And if that's the case, and the judge believes that, that doesn't look good for Rob Wood. Let's go live.
To minimize bias is critical.
Now, you had an occasion in this case to review the tape recording that Mr. Means provided to you. Is that correct?
I did.
And you had an opportunity to review the transcript that's been admitted as, I believe, exhibit number 1 in this particular case. Is that correct?
Yes.
And as part of that process, you prepared a report, approximately 24 pages, detailing your findings in regards to that review. Is that correct?
I did.
And based on your experience and knowledge in this case, and having testified numerous times, you came up with some conclusions regarding and findings regarding this tape recording. Is that fair?
Regarding the narrative on the recording, I did.
And before I start, I guess I want to clarify something. You're aware that this recording took place. Would you describe the interaction between Mr. Wood and Ms. Shiflett in the first 18 minutes as an interview?
No, not at all.
What would you describe it as?
I would describe it as a session or a meeting where the witness was obviously being greeted for the first time to educate and inform the witness of the prosecutor's perspective, theory on the case, and to elicit the participation of the witness in that theory of the case.
Okay. And Judge, I have a lengthy discussion that's going to take place with Dr. Davidson. I would ask if the court wants to take a break at this time before I engage in this lengthy discussion regarding his findings, or would the court like me to proceed? And I will defer to the court's wisdom.
I think this would be a good time to take a mid-morning break, so we'll do that. Before we move on, there was one concern I wanted to address there with Mr. Davidson. Mr. Davidson, in offering your testimony here, are you have you been reading from or referring to anything outside of just your own memory here?
They leave us right without the conclusion. Jennifer, I'll stick with you on this. What do you think his conclusion is about reviewing that? I think it was an 18-minute interview between Rob Wood and Summer Shiflett. He said it wasn't quite an interview; it was more, this kind of session or meeting. Where do you think he's going with this?
Well, listening to his opening qualifications and laying out best practices, I think that our prosecutors in for some trouble here. Prosecutors generally are very, very cognizant of this for this very reason, because they know they can be held accountable if they interfere in a case in a manner that might cause a witness to talk about things that aren't actually true, or make things up, or leave things out based upon their discussions. So, having listened over the last half hour or so, I think our prosecutor might be in a little trouble here.
And that'll put the case, I imagine, in maybe some jeopardy. You bring in a new prosecutor. This prosecutor ultimately becomes a material witness who would be subpoenaed. And that just creates complications for a case that a lot of people are not only viewing, but are invested in as well. Now, Lisa, again, learned a lot from that recording. And if we take everything that Rob Wood said to Summer as true, he said the case against Lori was stronger than that of Chad. Said Chad is very manipulative, but really hit the focus on Lori. What does that tell you?
That was their belief. I think going forward, she was put in a position of thinking that they have enough in their hand to go against Lori, but using Chad's manipulative nature kind of coerced Lori to do what she allegedly did. So I think that kind of potentially put her on pins and needles to think, wow, they have this information now, and this could change everything going forward. What could potentially happen to my sister?
And Jennifer, we talked about it a little bit earlier, but let's get more into the details. If the body of Tylee is too destroyed, too decomposed, they can't have an answer as to what the cause of death, who did what. Walk us through that. Walk us through some of the challenges that we're learning from the crime lab. I mean, that body, both of those bodies have been there for quite some time. We didn't know if the prosecution was just not revealing a lot of information at this point, if they were going to hold off charges, or what they knew. But this interview, this call from this recorded conversation back in October, it's pretty recent. They don't have more information. What do you think about that?
I think that doing autopsies and doing the scientific research around bodies that have been severely decomposed, particularly burned, is just very, very difficult. And there's some things you can ascertain right away, but there's some things that just take a long time. And part of that is doing the specific and specialized testing to determine if there was poison, if there were drugs involved. A very intense scrutiny of the remains to see if there's any sign of damage to the bones, if there are any small microscopic things that you see that might lead you to what happened to these children, and particularly bodies that are burned is just so very difficult. So it does take a long time, because you don't want to not cross every T and dot every I. You want to make sure you get all information, because whatever the answer is going to certainly be challenged by the other side, and so you want to make sure that everything is done incredibly thoroughly, and that just time.
Yeah, absolutely. There is a lot riding on this. People want answers. They want justice. And if you trying to put the pieces together, it may seem that Alex Cox, Lori's brother, may have been the actual murderer, and that these two were going to be charged with conspiracy to commit murder. We're getting more of the picture, and it's not a pretty picture. Lisa Lockwood, Jennifer Shen, I appreciate you both taking the time. That's all of us, for all of us here. Law&Crime Report will be back tomorrow. Stay tuned. We're going to follow this.